everybody. Welcome to the Parenting Coordinator Brown Bag Lunch. I'm excited to have three local parenting coordinators up here. Erin Sanford in the middle, Nicole Maxwell over here, and Carrie McCormick on the end. This program was recommended on somebody's evaluation from one of our previous Brown Bag Lunches, so please find your recommendation, find your evaluation sheets in your packet today and give me some more good suggestions. I will take them. Quick reminder, couple brown bags coming up. Next month we're doing Working with Sovereign Citizens. It's almost completely full, so if you're interested, stop at the circulation desk and sign up for it. In June we're going to be doing the Legal Aid Center will be showing us their brand new legal aid portal that's statewide that they're working on. Should be launching just about the time of the Brown Bag Lunch program. And then in July, we're doing a repeat of the expungement and sealing of records program that we had earlier in the year that completely sold out. So if you're interested in that, stop by and sign up for that one. And we'll be working on August through the end of the year. I'm working on them right now, so you'll get notice of that soon. I will let these ladies take it away. Please.
Hi everybody. Thank you for coming to listen to us speak here for a little bit about parenting coordination. In addition to parenting coordination, and Carrie and Erin and I are family law attorneys here in Franklin County. We also practice in other counties. We do mediation, we do guardian ad litem work, and Erin does probate work as well. We were part of the first group to complete the training for parenting coordination here in Franklin County. And since that time, we've spent a fair amount of time together. We meet about once a month and talk about the implementation of the process, how it's going, and best practices as we move forward in getting this process up and running in Franklin County. So overall, parenting coordination is a child-focused alternative dispute resolution process. So generally that means it's a process for parents unable to resolve their parenting disputes and those parents who seek a resolution of those disputes through the courts. So in this process, the PC process, an impartial third party, typically an attorney or a mental health provider, but not always, is appointed by the court to help parents implement their parenting order by facilitating the resolution of those disputes. So to talk a little bit about the history of parenting coordination, the concept of PC work developed out of a special master process in California and then a study that was done in Colorado by two psychologists in the 1990s. So special masters were attorneys who were appointed by the courts and had the ability to write orders. And their job, their function, was to settle the disputes between parents. They then, if they were unable to settle those disputes, could issue an order. They're a little bit different than how that PC process has developed today. They didn't work with these parents for long periods of time. They didn't have ongoing relationships with them. And they didn't teach these parents the skills that they need to hopefully be able to resolve these disputes on their own at some point. After that study was done in Colorado regarding high conflict parents, the PC process really began to develop as more of a multidisciplinary process. So we now have a lot of mental health providers, a lot of mediators, a lot of attorneys who are doing this in different states. It's not mediation, it's not arbitration, it's sort of somewhere in the middle. We've called it mediation on steroids, but it's not precisely accurate to say that either. Our goal is to get these parties to be able to work through their own disputes using mediation skills. The big difference, I think, between that, well, not I think, I know, the big difference is that if they are unable to reach that resolution with our assistance, then we are able to issue a decision provided it's within our scope of authority. And I'll talk a little bit about scope of authority as we go on here. So this process has been adopted by nearly all the states, I believe, at this point. Some states have abolished it and are not using it anymore. Ohio is actually late to the game on this. We just started, I believe we adopted Rule 90 in 2015. Or 2014, and then Hamilton County and Cuyahoga County sort of led the way in getting this process up and running within our state. They were the first couple of states to really start using this a lot. Other states have adopted it since. Franklin County we adopted our local rule in 2015. Some other states in Central Ohio that have done it would be Fairfield County, Delaware, Licking County. I'm not sure to the level that those counties are using it. I think Delaware is using it a fair amount. Licking County, I still don't see it as much down there, and I spend a lot of time in Licking County. So, talking a little bit more about PC work specifically in Ohio. So as I mentioned, child-focused alternative dispute resolution process. So PCs in Ohio are required to have substantial training. I'm going to let Erin talk about training in her section of this, so you'll hear a little bit more about what's required for that. And then the parents who are right for this process are the high conflict parents. So high conflict isn't defined in our rule, which is Superintendent's Rule 90. But we sort of know high conflict when you see it. If you practice in this area a lot, you see these parents who cannot agree on who's going to take Johnny to soccer on Tuesday, who's going to pick up Molly's dress from the cleaners on Saturday to get her to the dance on time. They can't even agree that today is Wednesday. Those are the type of parents that we work with in this process. A lot of times those people are very litigious, and there's been a lot of post-decree actions before they get to us. They may have tried mediation in the past, and mediation wasn't successful for them, or it was inappropriate for them in some other way. So why do we feel like we need this parenting coordination process? Well, we know that children that are exposed to this ongoing conflict between parents are at significantly higher risk for a lot of issues as they grow up. They're at risk for social issues, for academic issues, for mental health problems. A lot of times they have trouble in their own relationships as they get older. And we're hoping that we can reduce that by reducing the parental conflict through this process and shielding the children from their disagreements, reducing these risk factors overall. So some of the goals of parenting coordination, we want to reduce court involvement. We want to have more timely resolution of disputes. We want these parties to learn communication skills, to learn negotiation skills, and to prevent and resolve these future disputes before they get to the court process, before things get more adversarial between the two of them. Overall, we're hoping to help these parents build a more collaborative co-parenting relationship. As a reminder, this process is very child-focused, so all we're talking about when we do this is the kids and implementation of their current parenting order. So we're not talking to them about their property. We're not talking to them about who cheated on who in the marriage. We're not talking to them about their hurt feelings. We're talking to them about moving forward. How are we going to implement this plan to care for the child and provide the children with the well-being that they need so that they can stay out of the middle of their parents' arguments and grow up to be happy, well-adjusted adults, which really is the goal here. So we all try to mediate the issues between the parents before we get to the point where we can issue a decision. As I mentioned earlier, if we cannot get them to a place where they can reach an agreement, they can resolve those issues that they may have between them regarding how their plan should work or how it should be applied, then we are able to issue a decision. What decisions we are able to issue, it depends on our scope of authority that's in our appointment order. And I think you guys all were able to pick up a copy of our appointment order here in Franklin County. It's a 4-page document, and they had it on the shelves out here as you come in. So if you look to that order, you can see in that what is within and outside of our authority. So under Section 3, you see the powers and duties of the parenting coordinator. So things we cannot do. We cannot determine whether to grant, modify, or terminate a protection order. We cannot change the terms or conditions of a protection order. And we cannot change the penalty for a violation of a protection order. We can't change the designation of the primary residential parent or legal custodian. So if mom has sole custody, we can't decide that dad gets sole custody. And we can't change the primary placement of the child. So if you look now to Section C, you're going to see a very long list of things that we can do. And I won't bore you by reading through all 22 of those, but some of those include things like if the parents have a dispute about when the kid's bedtime should be. So if somebody thinks that Molly should go to bed at 8 o'clock and somebody else thinks Molly should go to bed at 9 o'clock, that's actually something we can try to help these parents resolve and issue a decision on if we're not able to get them there. If somebody thinks that the kid should be able to pierce her belly button and the other parent doesn't, that's something that's in this list that we can address. School placement parent is also something we can address. That is actually on our list. When we address school placement, though, it's important to remember that that is not primary placement of the kids. So if we have a situation where mom lives in Cleveland and dad lives in Cincinnati, we can't say that mom, who was the custodial parent and the kid went to school in Cleveland, is no longer going to hold that power now that the kid's going to go to school in Cincinnati, because that now changes the primary placement of the child, meaning that suddenly their time allocation is completely changed. Now, if we have parents who have a 50-50 split and they both live here within Westerville and Dublin, maybe we can change that. Maybe we can address that school placement issue because they can continue to have that 50-50 split of time. We also have a catch-all in here that says any other parenting issues not previously addressed by the parties. So that gives us a little bit of wiggle room to address things outside of the order, but we try to be pretty specific on what we do address. A lot of times, attorneys and parents will agree to something else that they want us to touch on, something else they want us to talk about, and we ask that that actually be written into the order before we're appointed, because that really helps us keep our parents focused on what they should be working on. And something that we come across a lot, people don't know the difference between a PC and a GAL, so I think that's something that Erin's going to talk about for us.
So there are a lot of differences and similarities between a guardian ad litem and a parenting coordinator, as well as other roles that parents often come into contact with when they're in a high conflict situation. A lot of other professionals that they're familiar with already are likely attorneys, the guardian ad litem, mediators, social or home investigators, a parenting plan facilitator or a parenting coach, therapists, counselors, sometimes financial advisors, and sometimes arbitrators. And although a parenting coordinator is not the same as any of these roles can often be confusing for some attorneys, because we often fill those roles in various ways. So all three of us work as an attorney, we practice family law, we all work as a guardian ad litem within the domestic relations court, we've all worked as attorney advocates for the children, mediators, and parenting coordinators. So we often use a lot of the same skills that we use in these other roles as a parenting coordinator to help us. A guardian ad litem and parenting coordinator, for example, are both appointed by the court at the request of a party or by the court's own determination for the need. A mediator could also be appointed by the court, but a mediator could also be decided to be used by the parties separately without court order. The guardian ad litem is generally appointed at the beginning of litigation, where a PC can be appointed at any point during the litigation. More often than not, one is appointed at the end of a case, and this is to help implement the parenting plan, the shared parenting plan, deal with issues that arise as they're trying to work through their plan, and then hopefully keep them from going back to court and filing for another modification. It's also a lot of the parenting coordinator's preference that we're appointed at the end of the case rather than during the middle of litigation. We have found that it is a lot easier to work with parents through the parenting coordination process if they are not currently active in litigation. The effect of appointing a parenting coordinator during litigation is also different than the appointment of a guardian ad litem during litigation. The main reason for this is that a parenting coordination appointment can stay the case, which means that the case is put on hold, and maybe occasionally the court will schedule a status conference, but there's nothing going on in court during the PC appointment generally. Whereas in a guardian ad litem, they're actively working during litigation, they're doing their investigation and reporting to the court. A PC also generally does not attend court appearances unless they are subpoenaed by a party or requested by the court to be present. They're not going to be showing up at the party's court hearings, also unlike a guardian ad litem, where the guardian ad litem is present at all hearings. The guardian ad litem is also generally discharged at the conclusion of a case, whereas a PC can remain working with the parties for a much longer time afterwards. The parenting coordinator is going to make decisions for the family if they're not able to reach one on their own, and a guardian ad litem, in comparison, is making the recommendations and reporting information to the court, but cannot make the decisions for the court. Same thing with a mediator. They're helping with the parties reach an agreement through the mediation process, but they are also not making decisions for the parties. The parenting coordinator should always attempt to facilitate resolution of any of the issues with the parties. However, the parenting coordinator, although they're using a lot of mediation skills, they're not acting in a formal role as a mediator. The effort to resolve an issue with parents can use therapeutic, mediation, educational, and negotiation skills. And this is not going to disqualify a parenting coordinator from issuing a decision in the event that they're unable to help the parties facilitate an agreement between the parents. Parenting coordinators also, like guardian ad litems, can educate the parties on the children's needs and make recommendations to the parties. But again, if the parties are unable to reach that agreement, the parenting coordinator, unlike a guardian ad litem, is going to be able to make a decision as long as it falls within the scope of the order of the appointment. And then the two, a parenting coordinator and a guardian ad litem, often consult with outside resources such as teachers for the children, therapists, physicians, attorneys for either party, family members. They can review school records, they can review medical records, and then through that, the parenting coordinator can assist the parties by providing some education based off of that information to help the children with their developmental needs, the effects of the parental separation on their family members, as well as co-parenting and parental communication. The parenting coordinator is also going to be able to help monitor compliance with the established shared parenting plan, companionship plan, or whatever parenting time plan that the parties have set up. The parenting coordinator is going to be using all these skills through their training to assist the parties in resolving these issues. Another thing to be careful about if you do become a parenting coordinator is to make sure that you are not serving as multiple roles as a parenting coordinator in addition to any of these other roles to create a professional conflict. So for example, a child's attorney or child advocate cannot become a parenting coordinator in the same case. A parenting coordinator cannot go from that role to a guardian ad litem role. Mediators also need to be cautious about becoming a PC in some cases, and that's even with the consent of the parties, because the differences in the role and the potential impact of that role can have changes and impacts on that family. A parenting coordinator should not become a custody evaluator either during or after the term of the parenting coordinator's involvement with the family. And same thing with any mental health provider. A parenting coordinator should not serve as a therapist, consultant, or coach either prior to becoming appointed as a parenting coordinator for that family or after they have served as a parenting coordinator for that family. Another obvious role transition that should not occur is an attorney for one of the parties should never become a parenting coordinator for those parties, as well as a parenting coordinator for the parties should never become an attorney then. There's another important difference between parenting coordination and other roles, which is confidentiality. Parenting coordination is not a confidential process either for communications with parents, their children, or for communications between the PC and other parties that they are working with, or even with the court. Confidentiality is also addressed in the PC appointment. So that same appointment form that Nicole went over, Franklin County specifically states that communications between the parties and the parenting coordinator are not confidential. Therefore, the written and oral communications, negotiations, and statements made by the party in the course of working together may be disclosed to others. Information provided by the parties in either discussions with the parenting coordinator or in writing with the parties will be considered by the parenting coordinator when making decisions and may be disclosed in his or her written decision. The parties are also put on notice in Franklin County's order that if the parenting coordinator may disclose information if he or she has reason to believe that a child is in need of protection, if either party or another party is in danger of bodily harm, or if he or she learns of the intent to commit a felony. The order also provides that a parenting coordinator has a duty to report to Child Protective Services, law enforcement, or other appropriate authority of any suspected child abuse, neglect, or any apparent risk of serious harm to a family member, child, or other third party. Another noticeable difference, if you've compared the list of parenting coordinators versus guardian ad litems in Franklin County, is that there is a difference in the hourly rate for a lot of PCs, in that the typical hourly rate for a parenting coordinator is much higher than a guardian ad litem's hourly rate. One of the reasons for this is a parenting coordinator is a qualified individual who has completed specific training prior to his or her appointment. Plus, this also includes a continuing education requirement on a yearly basis. On average, all PCs have at least 80 plus hours of training prior to becoming appointed on a parenting coordinator list. The prerequisites to taking a parenting coordination class include the fundamentals of mediation training, a specialized family divorce mediation training, which is 40 hours, at least 14 hours of specialized training in domestic abuse and dispute resolution, possess a master's degree or higher, a law degree, or have an education experience that is satisfactory to the court. They also need to have at least 2 years of professional experience involving or experiences with situations involving children. So that can include parenting coaching, counseling, casework, legal representation of family law matters, serving as a guardian ad litem or mediator, or other equivalent experience that's approved by the court. Other reasons why we feel that the PC hourly rate is higher than a guardian ad litem rate is because the fees are not protected by the court, because the parties are not protected by the court.
I'm just going to rephrase that again. The parenting coordinator is not a party to the case. Unlike guardians ad litem, who are parties to the case and can file their own motions and can seek enforcement of court orders, including but not limited to fee orders. Parenting coordinators are not parties to the case. So while it is different in different counties in Ohio and it's enforced differently, the expectation here in Central Ohio has been that those fees must be enforced separately outside of the court. And I think unless there are rule changes or other mechanisms put in place, parenting coordinators lack standing to file a contempt for a failure to pay parenting coordinator fees because you're not a party. One parent or the other, the parent that's participating in good faith, could certainly file that contempt, but the parenting coordinator is not a party to the case. Tell me how a non-party has standing to file a contempt. Kind of the same way that family courts would order a custody evaluation. If the custody evaluator is not being paid, the custody evaluator may not file a contempt in the case. The court certainly has the ability to enforce its orders, but one of the reasons that the hourly fee rates are higher, and one of the ongoing kind of developing issues, is how do parenting coordinators enforce their fees? So I just wanted to talk a little bit more about particularly how the PC has to enforce those fees right now outside of that DR process, unless a party to the case would have an interest in filing that contempt themselves. And I'm sorry to interrupt.
It's okay. And to just finish that up a little bit, the guardian ad litem fees in comparison, the guardian ad litem can file a contempt, and their fees also can be ordered to be non-dischargeable in bankruptcy. Another reason is we are dealing with, best way to put, the worst of the cases a lot of times. There's a lot of high conflict with these parties that we are trying to help them reach agreement. And a lot of times with the high conflict parents also come with a lot of complaints, which also exposes parenting coordinators at risk for having more complaints filed against us professionally with our licenses. Additionally, one of the differences with parenting, at least how a lot of us in our process with parenting coordination, we don't meet generally with parents one-on-one. So the parents don't have the opportunity to monopolize our time like they can or try to as a guardian ad litem. So the time is hopefully being equally dispersed between the two parties. The parenting coordination fees should be addressed in two ways. First, in the court order, and in Franklin County's court order, they address it by requiring the deposit amount for each party to pay to the parenting coordinator, as well as a percentage of the total fees that each party is responsible for paying. The parenting coordinator also has to disclose and explain the basis of their fees and charges to the parties as well as their counsel. All of us do that by having a fee agreement. The charges for the parenting coordination services shall be based off of the actual time expended by the parenting coordinator or as directed by the local rule if there is one. All fees and costs need to be appropriately divided between the parties as directed by the court order or as agreed upon by the parties in a written fee agreement and with the approval of the court. However, I would like to note, one of the things we don't want to spend time on when we're trying to look at the big picture of what we're supposed to be doing is helping the parties reach an agreement on what the division of their fees are. We really prefer that it is done through that court order and not something we have to discuss with the parties. And then prior to beginning the parenting coordination process, the PC should do this in writing and explain to the parties the basis of the fees, the costs, the method of payment, any fees that are associated with any postponement of meetings, cancellation of meetings, as well as any other items related to fees. Some of the activities that a parenting coordinator is likely going to charge the parties for is going to include time spent interviewing the parents, talking with the children, or interviewing other collateral sources of information, preparation of any type of agreements that the parties have reached, correspondence to and from the parties, because there's a lot of communication that often occurs between the parties and the parenting coordinator outside of the regular meetings. Any type of telephone or electronic communication, travel, preparation for court if the parenting coordinator is being required to attend court, the actual court appearance, any depositions that might take place, or any other meetings that someone is requesting a parenting coordinator be present for. Sometimes schools request that the parenting coordinator come and attend a meeting with the parents, so that could be an example of a different type of a meeting. The parenting coordinator is often going to request a retainer or advance deposit prior to starting the case. A majority of us also require that there is a positive balance on retainer at all times as part of our fee agreement. And the parenting coordinator is also, just like with any attorney, required to maintain the necessary records to support their charges for services and expenses, and needs to make a detailed accounting of those expenses if requested by the parties or the court. So I'm going to turn it over to Carrie, who's going to talk more about the process and how she deals with some of her specific cases.
So that was the academic side of things, and I like that they do the details on things. Mine is kind of a look inside the sausage factory. I have, my name is Carrie McCormick. I have been practicing exclusively domestic relations law since 2001. I've been a Ohio State Bar Association certified family law specialist since 2008. I've been doing guardian work for almost all of my practice, and was one of the first class of parenting coordinators added to the list when the role finally came into effect in Franklin County. I've been appointed on between 40 and there were a couple of others that came in this week, so I'd say between 40 and 50 parenting coordination cases. Not all of those have ended up in an ongoing process with my office, but over the last 4 years, that's about the volume that has come through my office. I know that this is being recorded, so let me also say that any opinions that I express are my opinions only. You should not attribute them necessarily to my colleagues or to parenting coordinators in general. I feel like everybody's entitled to my opinion, so take that with a grain of salt. I'm just going to share with you kind of some of my experiences and how the practical implications of the parenting coordination process go. Just so that I can have an idea about how specific I'm going to be, can I see how many attendees do work in family law at all? So roughly half or so of our audience does some family law work. So I'm going to do some high-level general things also. So when a parenting coordinator is appointed, there are, just like there are different guardians with different skill sets, I think there are different parenting coordinators with different skill sets. We see mental health professionals in those roles, we see attorneys in those roles, and then within the attorneys, I will say there are the more touchy-feely, kumbaya attorneys that do the work, and I think they feel great need for certain kinds of families who benefit from that kind of the process. I don't know if it's personality or practice. I don't tend to get those. I'm getting high conflict personalities who have monopolized a litigation process and who typically, I will say, the people that come into my office, I don't have high hopes for tremendous personality change or attitude change from these parents. I operate more often than not as damage control rather than really being an impetus for change. There are, if anybody golfs, you know there's always that one shot during the round that keeps you coming back. So there are the occasional cases where I really do see some tremendous growth or change in individuals and see that process work the way I think it's theoretically intended to. Unfortunately, particularly in family law, and I have no experience to say whether it happens in other types of law, we have about 10% of the cases that monopolize 80% of the court's time. There's a disparate application of court time to certain kinds of cases that keep revolving in that litigation track. And most of the studies that I have seen show that ongoing conflict, that ongoing litigation exacts costs from the family system as a whole and has a negative impact on children. Sometimes it's an only option. That's our place of last resort. What the court now has at their disposal is another tool to try to dampen that conflict a little bit, to try to give the parties an alternative process to manage their day-to-day issues. If anybody wants good literature on dealing with high conflict personalities, one of my writer crushes is Bill Eddy, E-D-D-Y, who does, he's a JD and a mental health professional, does a lot of writing on how to deal with high conflict personalities. Also does a really good, and it's been kind of weeded down, he does a very good protocol on communication guidelines between parties, or just how to respond to any kind of high conflict communication. It's helpful for me in my job in dealing with colleagues, or even makes me look at how I draft my communication. So that process is called BIFF, B-I-F-F, and Bill has a number of writings and a number of books out that help dealing with high conflict parents. I'm dealing with those high conflict parents whose inability to agree is damaging their child. I'm also dealing with parents with specific management issues, parents with non-traditional work schedules that require some flexibility in the parenting time schedule, and the court is not confident that the parties can resolve those issues together. Emergency room doctors, firefighters, people who work second shift, parents with changing work schedules. Sometimes my job is to do some of those logistics and help them work out exactly what their parenting time schedule is going to look like for the month within certain parameters that the court gives me. I'm not inventing a new schedule every month. We vary from the baseline, taking those schedules into account. I also see cases where parents have children with specific medical needs, and there needs to be a case management or a kind of an information flow police to make sure that the providers are talking with each other, to make sure that the parent tasked with making those decisions has the right information to do that, and that they're communicating everything that they're supposed to with the other parent. So there's also a kind of a case coordination or a case management function to parenting coordination as well. I typically see parents who lack the skill and or the willingness to work together in the best interests of their children. One of the nuances that I want to talk about very briefly is when parents come to me in the parenting coordination process with a custody order versus a shared parenting order. And because half of the room doesn't really work in family law, let me just briefly describe the two only in terms of the decision making. This doesn't apply to the parenting schedule at all. In shared parenting, the parents endeavor with varying degrees of controls to work together to make major decisions for the child. In a custody situation, one parent is tasked with the responsibility of making those major decisions for a child. I tend to, and I believe that my process should acknowledge the right of a custodial parent to make general major decisions for a child. So I look to the scope of my authority in the appointment order. I look to specific instructions from the court, but because I don't have the ability to unilaterally change court orders, I do believe there's a difference in my approach based on whether one parent has legal custody or whether it's a shared parenting situation. Some deference is given to the decisions made to parents who have legal custody of their child. Let me talk about my intake process and how people come in to see me. One of the things that's very important and drilled into parenting coordinators' heads is we need to screen. I look for domestic violence components in these relationships. That's a big term. I can't claim to completely understand all of the nuances of that. What I'm looking at really is, can both parties come to the table and feel a relatively equal sense of power in my office? Briefly, domestic violence is not simply about pushing or shoving or physical violence. It's about coercive control and whether one party is in inappropriate ways exerting control over the other party such that they can't freely participate in my process. In order for this to work, because it does depend so much on buy-in, I need both parties to feel that they're at their best when they're working in my process. So I do have to be sensitive to those issues as they present to me. And I'll tell you, a lot of it is not me going back and playing detective and determining what happened. It's about me understanding each parent's perception, because they come to me with the perception and the experience that they have. So it's important that I acknowledge and honor both of their perceptions and experiences and not decide who's telling the truth and who's lying. It's about getting everybody into my process on a relatively equal power balance. So I do screen for that at the beginning individually with each parent without the other parent in the room. I also tend to, unless I see a problem and need some specific management skills, I tend to ask them to please ask to speak with me separately or to let me know if anything about that changes. In a best case world, I'd pull them each in separately every session and find that out, but economy and presuming that these parents are empowered to tell me those things, I don't necessarily pull them in every session to do that. When I do intake with parents, I also decide whether I want to meet with them together or separately. And like Erin said, these are parents who have had their own gladiators fighting for them through this process. These are parents who you talk to each of them separately and you're not sure they're even describing the same child. So I try to, my presumption is I want them in the same place at the same time. I don't want to give them the opportunity to split or to tell me something different than they're telling their co-parent, or that they're telling somebody else. It also kind of holds me accountable because I'm not acting one way or showing partiality to one parent or the other. When I say something, I've got to say it to both of them at the same time, and that keeps me in what I think is a more impartial role. And when I say impartial, that refers to my process. It does not refer to the outcome. I end up taking sides on things. So I want to make sure I'm gathering the information from both sides equally, although my decision may not affect them both equally or meet each of their goals. So having them together helps me be more transparent in my process, which I think is important because typically these parties have spent years one or both of the parties have spent time manipulating within the legal process without a lot of that communication between themselves. It's also important for me to explain my role to parties and to get informed consent to the process. I need to make sure they understand what my process is, make sure that they know that it's not confidential technically, and make sure that they are consenting to be a part of the process. If either party will not sign my initial documents, if they will not make an appointment or comply with my initial requests, I send a report or a PC decision to the court that says they've not met these responsibilities. I can't function with just one parent. I'm declining to schedule sessions unless or until this parent works within the process. I'm not going to start initially with just one parent. Some parenting coordinators will do that. I will not, because I don't think that that's the design of the process. It's also important, particularly with the high conflict personalities, for me to set strong boundaries and expectations for these parents in my process. If I tell them the other parent has to be copied on all communication, and I'm not going to read it unless I see the other parent CC'd on an email, I'm going to stick to that. I can't set boundaries for high conflict personalities and refuse to follow them because I'm rewarding that personality that does not comply. And it's kind of teaching. I don't look at it as punishment. I look at it as if they can't work within the process that I have, that reflects a bigger issue, and maybe they ought not be in this process at the same time. So I generally prefer them both together. I have to set strong boundaries for them. One of my boundaries that I set in some sessions is timers. We'll be talking about an issue. I will determine, and these are great because I don't have to push any buttons. I just pick what number I want to give them for minutes. Put that side up, the timer beeps and starts counting all by itself. And I don't spend a bunch of time. Amazon, awesome. 2 AAA batteries, not included. The other great function with these, or setting these boundaries, is the parents that I tend to get haven't spent a lot of time listening to each other. And when I do this, I say, I'm not going to interrupt your time unless something is out of bounds. I'm asking the other parent not to interrupt that time. So they actually have to listen to what the other parent is saying. Sometimes I see them scribbling furiously. And then when I get to the second parent for their time, I say, okay, you have 2 choices. You may choose to respond to all of the issues that the other parent initially raised and tell me why they're wrong. In which case, you're really giving them a good amount of control over this process because they've dictated what our topics and what our agenda is going to be about this issue. Or you can use your time to tell me your perspective on these things and make sure that you're heard in this process also. And it tells me a whole lot about personalities to see who is able to choose which option. I start parents off generally talking with me, not talking with each other. That's another kind of training wheel that I use. I try very hard, it's difficult sometimes, especially with my mouth, to model for them the kind of respect and behavior that I wish for them to bring more peace to their family. It's hard for me because sarcasm is one of my poor coping skills, but I really try on good days to model for them the kind of respect, and even if I completely disagree with what somebody is saying, it's a good exercise for me to say, you might be right, and let them feel heard in that process. So it gives the other parent validation, it lets everybody feel heard, and sometimes that's all these people need. So I'm coaching as I'm working through this process. I also establish boundaries around when they can contact me and what kind of response time they can expect. If they are calling me needing an immediate answer, they should be calling 911. I am not an emergency management tool. I'm not Child Protective Services. I'm not the police. So if they feel something is so dire that it needs that kind of attention, they should be calling someone else. And sometimes for high conflict personalities, letting something die down and not responding to it immediately helps them to resolve it themselves. The world turns without the PC's involvement sometimes also, and some of these people have had professionals making decisions for their children at every turn, and particularly when money is not an item to dissuade them from invoking that process. I want them to try to resolve some of these issues themselves as they can. The next thing that I do after I explain the process and kind of set those initial boundaries, I want to define who our team is. I want to know who it's important for me to gather information from, who are the people that can provide me information about this child's best interests. I also have to decide whether I want to interview or take information from the child. And it's a touchy decision, and really I think it's a gut thing. I don't have any academic way to tell you when it's appropriate and when it's not. These children have typically been entirely too involved in their parents' conflict. I start with the presumption that I don't want to talk to these kids. That varies sometimes when particularly children are older or they have very specific wishes or interests. Sometimes giving the child a voice in that process is helpful for the child. And I have some cases where I do that, particularly with older children who need to feel heard in the process and have something different to say to me than either one of their parents do. So that's another choice that a PC will make, whether to involve the children or not. The next piece that I usually do is I want to hear what the parents' goals are. I know typically I get the form appointment order. Sometimes there will be changes. What's helpful for me is knowing what the court expects of me. And because I can't, as a PC, just go talk to the magistrate and say, hey, what do you want? Some guidance in an appointment order or another order is important to me, or from the guardian, to convey kind of the court's message. It's important to me to know, what am I looking to do here? Do you expect total 180-degree makeover, because my magic wand is not working today? Or are there specific things that affect this family that I can be helpful in managing?
Do you
Go
get
ahead,
the
Karen.
guardian's report, or is it appropriate for you to get it, or do you care?
If it's been filed, I have access by request to all of the pleadings. I do not have access to the pleadings by e-filing because the parenting coordinator is not a party to the case. I cannot, from case information online or from e-file, access that whole file to see the documents.
Okay.
The court has been very cooperative with parenting coordinators who go to a bailiff or a court officer for the magistrate assigned and say, hey, can you print me these documents? I need them for my file. Typically, the parties or their counsel are responsible for providing those. It's usually cheaper if they don't do that for me to just go to the court and get them rather than to bother attorneys. And frankly, I don't ask parties for them because I don't know if I'm getting the full information. I'd rather have it from another source just to cover myself. So I do want to hear what the institution's goals are for these parents, but I also want to hear from the parents themselves. I want to know if they're going to look back and say, wow, this really worked. What changed? One of the things that I like to do, and I think it drives parents crazy and I don't care, is ask them to phrase their goals in a positive way. I don't want to hear, she never tells me about medical appointments. I want to hear, I want the opportunity to know about and to be present at medical appointments for the child. That's a positive statement. And it's sometimes people feel like I'm condescending when I ask them to do that, but I want them thinking in those terms. It's child-focused, it's looking forward, not looking backward, and it's working them towards a positive goal, and helping them to see that there are better opportunities out there, and that everyone could be happier in the system if they could meet some of those goals. And that's about as touchy-feely as I get. Once we have those goals and we've chosen some realistic objectives, I gather information. I choose where to gather that information from. There's also an education component to my role. I tend to refer that stuff out. I'm not a therapist. I'm not a mental health professional. I'm not a parenting coach. I'm probably screwing up my kid every day. I try not to impose my parenting values on other people. Whether it is cultural or just different values or something that I'm less familiar with, I look at my biases pretty clearly and try to, I don't deny them, I think everyone has them. I try to control for them by recognizing where those can show themselves in my process. So I don't want to just replace my parenting goals or my parenting judgments for these parents. The education pieces of it, okay, I know how I would deal with a 4-year-old who doesn't want to put his shoes on, probably about 6 hours ago. I don't know how I'm going to deal with a 17-year-old girl who talks about wanting to hurt herself. There are better qualified professionals to add skills to some of these things. I think I'm undertrained and overpaid to do that kind of work directly. So I have, and all of us work to establish a professional network of referrals or references or even peers that I can call and consult with and say, hey, I've got what looks to me like, or what in the custody evaluation said was this kind of a personality disorder. What kind of treatment protocol or what professionals do you know that deal with that well? And I never give a single referral. I always give them at least in 3s, so that it doesn't appear that I'm partial to anybody. What time is this over?
1:15.
Okay.
Do you have the authority to make them go
No,
someplace?
and we'll get to that.
Okay.
So typically I tend to refer those out. Some parenting coordinators, particularly if they're mental health professionals, have the skills to do those things too. And I think that's fantastic. I just recognize where my limitations are. I'm often serving a communication or a conflict management function. I have had super high conflict parents who weren't allowed to send emails to each other directly until they got my gold star. Typically, those are situations where there has been an element of coercive control or some other pretty strong boundary violation, wherein it's as much of a safety issue or a personal mental health issue than anything else. Otherwise, I don't want to, and I don't have the time to, manage every case that way. So I will tell you that's probably an exceptional remedy. More often, I ask them to use an online communication tool that documents all of the communications that I have professional access to, and I can see what everybody's sending back and forth. The other thing I use with that tool is there's a calendar. Typically on a lot of these tools, there are some free services, there are some paid services. I don't let them write words to each other unless it cannot be reflected on a calendar. So if Billy has a doctor's appointment on April 30th at 2 o'clock, I want that posted on the calendar and not a message about it. It's training wheels. There's less opportunity for conflict, and it doesn't need the whole diatribe about who took him last or I scheduled this appointment because I think that you're doing. Just post it on the calendar. The professional, the time, basically what it's intended to be for, just the facts. So one of the communication tools that I use is an online program of some kind. I'm working to get these parents out of this emotional realm and into the business of parenting their children. They're not spouses anymore, they're not girlfriend and boyfriend anymore, they are parents, and that's a relationship that even if somebody has custody, does not terminate really at any points in their lives. There are weddings and graduations after children are 18. They are parents whether they like it or not, for the rest of their lives. Another function that I think is important and that particularly fits my skill set is to monitor, explain, and enforce the shared parenting plan or the custody order. Some people don't understand what those words say. Some documents are drafted with holes big enough that you can drive a truck through them. So I tend to give them my interpretation of the order or my explanation of the order to help facilitate compliance with the order. I also document failures to follow. It's not, well, one parent told me dad didn't pick up until 6:45 instead of 6 o'clock. Dad said that the kids weren't ready until 6:45. It's what can I prove? What do I have objective knowledge of? And that's what goes in my file. The parents can agree to deviate from a custody agreement or a shared parenting plan or a custody order. I am to document those agreements, and if it's agreed by the parents, I don't have to file it with the court. If the parents can't agree after that process, I can make a written decision so long as it is within my scope of authority. I'm going to tell all of you I am very selective in filing parenting coordination decisions absent agreement of the parties. It doesn't mean it doesn't happen. I tell them what to do, but I want it to be clearly within my scope of authority. We have a rule of superintendence on parenting coordination, not a statute. I don't have case law yet that develops what my role is that's worked through many courts of appeals at this point. I don't have case law on the enforcement of parenting coordinator decisions. I think there are some due process elements that you have to look at. In staying in the scope of authority, there's this existing Ohio Supreme Court case called Kelm, K-E-L-M, that says you can't arbitrate child-centered issues. That's an improper delegation of the court's judicial authority and judicial mandate. Well, by having this oversight process and by having the objection process, this is the same Supreme Court that issued the rule of superintendence that also issued Kelm. So I'm seeing there's some movement and some give in that. But I am super careful to stay within my scope of authority because I don't want to develop the case law and I don't want to make bad law where parenting coordinators are exceeding their authority and potentially exceeding Kelm. So that judicial oversight is an important piece of the process, and staying within my scope of authority, I believe, is an important part of my process to protect the development of parenting coordination in Ohio because we were so late to the party. The expectations of parenting coordinators and the use varies nationally. I've worked with a national organization for years that has, I'll put a plug in for anybody that does family work at all, the Association of Family and Conciliatory Courts, best CLE that I've seen. It's a multidisciplinary organization, involves mental health professionals, judges, magistrates, guardians, attorneys, PCs, all focused on looking at these family conflicts and what all of our systems can do to help address those. If anybody wants either Ohio chapter or national contact information for the AFCC, please see me afterwards. I can't say enough about the organization and its resources. When I don't think it's appropriate to use a parenting coordination process is as punishment for the parents. If they're truly awful, they're not going to work in my process. Or as a timeout. With the stay that comes along with the parenting coordination process, it's an easy parking lot for an overwhelmed court. It's not, nobody's going to buy into the process at that point. I also don't like the cases where a PC is appointed because other professionals have avoided difficult decisions. If this is a case that needs to be custody, make it a custody order and make those tough decisions. I don't want a punt with a mushy recommendation from a guardian or lawyers settling a case with really vague language and putting on a PC just to get the case done. I think we're doing families a disservice in those situations because we're not giving them the tools that they need to manage their system, and we may be creating expectations of a PC process that doesn't exist. I'm looking forward to fleshing out these roles. We're all open for precisely 2 minutes of questions before the seminar is finished. Mr. Doyle.
I mean, in part, I wonder, it sounds like, are these clients higher resource clients? You know, I mean, what's the, you know, I mean, to do this kind of work effectively, it sounds like parties might need resources. I have no idea. I'm not, Brett and I are here to learn, but Lieberman and I are from the 10th district. So, I mean, what kind of resources do these people have?
A fair amount of them do have additional resources, at least from my perspective, because obviously they need to be able to afford to pay the bill. And
Yeah.
they've already been through
Sure.
litigation, so they've already paid their attorneys, they've paid the guardian, now they're paying me.
Well, you earn your money more than earn your money.
I think so too.
Yeah.
But I don't think they're all very high income. I think we have some people who are middle class.
There's a range of hourly rates for parenting coordinators on the list. There are some, particularly mental health professionals, who are willing to do the work at a reduced cost. And for people who have those more limited resources, that's a great match because they can get their coaching and their skill building in the same place. I am typically referring these people out to other professionals for additional coaching or skill work if they're lacking in some regard. We can talk after the recorder's off about what the range of hourly rates are, but they do vary pretty greatly. Karen?
We all are supposed to do a pro bono one a year too.
No, we have to be open. We're not supposed to do it. I'm going to correct that. We have to be open to it with a certain range of duties. This thing can take on a life of its own. So if it's just a blanket pro bono PC case, no thank you, I'm going out a window. So the court may say 10 hours of parenting coordination. We have to be open to looking at that option. Don't tell lawyers that.
I appreciate it.
So the only comment I want to make is I think there's a tremendous dearth of people, a lack of people at the lower rates. Not that you should take lower rates, but I don't really believe it's available to a lot of the clients of the court, especially ones that are pro se, et cetera. And the work you're doing is fantastic, but it's really not very available to a whole lot of clients.
As is the case with so many of our court
I
resources,
agree.
there's an access issue. We're having more and
Yes.
more pro se parties. Absolutely something that needs looked at,
No
not
question.
something that I'm willing to put in my basket right now. So,
No,
yeah,
I'm agreeing
yeah,
completely,
yeah.
but in terms of a broader answer,
In general, there's an access problem for services for families throughout at least what I see in the family court systems.
How often do you render decisions? I know you're running out of time here, and do they appeal that? Is there any, is there any right to challenge that?
By local rule of superintendents as well, there is a 14-day objection period after the issuance of a contested parenting coordinator decision. I have had 2 objections filed. They have, one was rendered moot, and the other one is still under consideration. It'll be interesting to see how that develops. I have not seen any of the courts really devote a lot of I've not seen a lot of objections move through that process.
and it's all defined in the local rule, but I just want to make one plug, which is,
I want everybody to know this is Karen Ball who is keeping you late.
yes, so we put a PC on a case, it happens to be Carrie, but the fact that the PC is there, after one decision that she worked them through, or maybe 2, because she's there, they're making their own decisions. It's amazing. Every time I get a bill from you guys that says nothing owed, I know that the process is working. I think the other comment that we ran into with is some of the early PC appointments did not have a date range on them. And the magistrates, you guys may have comments about it, but maybe you just get the orders. I'm hearing a lot of magistrates and judges want to put it on just for 1 year, not very useful. If it's high conflict today, it's gonna be high conflict 2 years and 5 years. One magistrate said if we agreed, she'd put it on for 5 or she'd put it on indefinitely. In the beginning, we used to try to put them on indefinitely. That whole time range is hard one, but in one particular case I just had, they determined that the time range was 1 year, and so we had to file a new motion to reappoint a parenting coordinator, et cetera, which took more resources from my client that could have gone to the parent coordinator. So I think that's a black hole or a practice tip, I guess.
Well-
Get as long a period as you can if you really want them to have the tool.
And that may be a practitioner's part, and please leave if you want to, and we can talk about this separately, but as a parenting coordinator, I don't want those.
You don't want long ones?
I don't want long ones, I don't want it to be determined, I want a duration. When that duration ends, if we're working well in the process, I've had people agree to extend it, but I like the shorter duration.
You do. Shorter meaning 5 years, not 1, right?
I think my sweet spot is 2, but there are variations.
Okay.
Thank you.
Going on.